Releasing medical records. Updated information on information blocking and HIPAA's right of access. It should not take a federal investigation before a HIPAA-covered entity provides patients with access to their medical records. This is a high priority, as we've seen in the last 3 years from the Office for Civil Rights, making sure patients get quick, easy, and less expensive access to their medical records. Your office should already be implementing all of the guidance that we're about to go over today, as the Right of Access Initiative was published in 2019 by the Office for Civil Rights and is currently being codified into law. Information blocking became effective April 5th in 2021. They called it Data Liberation Day on October 6, 2022, when they expanded the information that patients have a right to receive from you under the information blocking regulations. Information blocking, not that important yet because they've not enforced it, but enforcement day is coming, so your practice needs to be ready to not be an information blocker. As I've stated earlier, the OCR has been flooded with complaints, and we've seen a lot of enforcement on a patient's right to access and get copies of their medical records. The average fine for violating the right of access has been $59,000, and it should be noted they have been going after small practices. So we're going to go over the 5 most common requests for medical records. A patient requesting their own medical records or a personal representative requesting those records. 2, when a patient requests their records to be directed to a third party. 3, responding to subpoenas, when it's the patient's attorney, what your responsibilities are, that are different from section number 4, responding to subpoenas when it's coming from the opposing attorney. Number 5 is provider request. Those requests for continuity of care, we'd better get ready to make sure that those are compliant and in place with the information blocking rules and regulations. The patient is in control. As you can see from this chart put together by the government, a patient can request records in whatever manner is most convenient for them. You then need to intake them, determine that they are a valid request, and then determine the fulfillment based on, again, the patient's request. The first part of this right to access is an acknowledgement that the patient has a right to receive all of the records in what is called the designated record set. That pretty much means all the records that you have used in the treatment and care of that patient. It includes billing records. You also have to understand that with this change, it means that if you have records from other providers, those must also be included. You do not have to go out and get additional records, but any records you have must be provided to the patient upon their request. The government wants to reinforce that with this US CDI version 3. So under information blocking, your EMR will be required to send any of the categories that you may have in your EMR directly to the patient portal. Under information blocking, it's very important that you do not go in and override the default setting of sending it to the portal and turn it off. That would be information blocking. So for patient privacy, the government does allow under the access guidance for you to require a written request. So if the patient is at your facility and they want to request their records for themselves or to be directed to a third party, you can have them sign your form, and I highly recommend that. However, if the patient is not easily available or states that it could create a barrier or unreasonable delay in the patient getting their records to require them to come in and sign your form, then you must take reasonable steps to verify who they are over the phone and make sure that is documented. The access guidance gives the patient the opportunity to pick the format and manner of access. So they to determine how you provide them the records. A lot of practices now say, if you want your medical records, go to the portal, they're there. We can do that, but if the patient says, I don't want to use the portal, I want to get them on a thumb drive, I want to get them printed out on paper, I want you to email them to me, Well, you are required to do what the patient requests. As long as you have that capability, the patient gets to choose in the form and format that they receive their medical records. Under the access guidance, the Office for Civil Rights really wants to promote that you need to be getting medical records to the patients in no more than 30 days. The actual standard is as soon as possible, but again, not taking more than that 30 calendar days. Under information blocking, the standard is immediately or within a reasonable time frame. We expect further guidance later on how these two are going to intermix, but right now, immediately means that if you have information coming into your EMR, it must be automatically pushed to the patient portal. If you're delivering records other than the portal, it must be within a reasonable time frame. So be aware that this is one of the top reasons that the Office for Civil Rights is finding small practices. So you really need to make sure that we are getting our medical records out in a timely manner. There's a proposed rule we expect to go into effect very shortly that will require you to prioritize any stat request by the patients or other providers. We will keep you up to date on that. Charging for medical records under the access right. Well, the Office for Civil Rights clearly stated that they prefer that covered entities do not charge for medical records. However, the law does allow you to charge in really one of two ways. First of all, you can charge a flat fee. That flat fee can be up to $6.50. Or you can use a reasonable cost-based fee. Now, HIPAA does not allow you to charge for all the costs associated with delivering medical records. So we have put together this pricing worksheet that you can use. So determining, you can add how much time and labor is involved with the top section of our worksheet, and then you can multiply the number of pages for toner and paper cost. You can add postage and any other cost, but if you go over $6.50, the Office for Civil Rights states that you must provide the patient with a medical records worksheet. Now, even if your state law says I can charge $1 per page, HIPAA is going to intercede here, and we have to go with HIPAA's rate. If your state rate says that you can only charge 10 cents per page, then you would want to go with the lower cost there. So there is also a requirement coming up in the proposed rules that we have to post on our website and in our lobbies what we charge for medical records. Again, we will be keeping you up to date on that development as well. So with the access guidance, a new term came out because before we always used an authorization form, but now there are actually two separate forms, access versus authorization. It all depends on who initiates the request. And yes, we do need two forms. So if the patient is requesting the records for themselves, then that is an access request. If the patients are directing their records to a third party, again for their benefit, then that is an access request. An authorization is when a third party is requesting the records. And it's a little confusing because when a court subpoena comes and it has an authorization signed by the patient, well, the patient records are going to be used for the patient, but in this case, because it's being generated by the attorney's firm, it's an authorization, even though, yes, in the end, the patient's records will be used. What that means to you is you can charge the state legal allowable for an authorization, whereas with an access request, we have to go to the access allowed fees. So here are two of the forms in the Releasing Medical Records Kit. Most of our forms, or all of our forms, are in Word. We also give you the PDF copy, but you can go in and modify them for your needs. So we have an access request and we have an authorization form. The next slides will go over how to use these forms. This is a patient access request. It differs from an authorization in that this form is specifically designed for when a patient wants to get a copy of their own medical record or send their medical records to a third party. So the thing to understand is that we do not have all of the required elements in an access request that are required in an authorization. But we do need to have, one, the records requested from office, and you should also put on the date that these are requested. An access form has a deadline. HIPAA states that within 30 days, the records must be delivered when a patient requests an access to their medical records. We should also make sure that we have the correct patient by making sure we've got their full name, and also always good to check the date of birth to make sure we're delivering the correct records to the correct patient. Now, patients can either, one, direct that they have their medical records delivered to them, or two, that they want to direct their medical records to another person or entity. So that's where we put that information. That is also required. Where are the records going to? Number three, what records are being requested? We want here, not a requirement, but we want to make sure that we help our medical records department by only putting in the records that the patient wants. So in this case, they want the progress notes, and so we should list those. And then also, what are the dates of service? So the patient may not want all the records going back through the last 5 years. They may just want maybe from January 2022 to present. And so we're going to fill that in again to help our medical records department. And then the patient gets to decide under the access guidance, how are they going to get these records? Do they want them paper, sent to the portal, on a thumb drive, or other digital media? And always remember that patient requests for their medical records are not subject to the minimum necessary standard. So they do get all the records that they request unless there's a reason not to send those records. And one of the exceptions would be for psychotherapy notes. Patients are not allowed to get copies of the records that are taken during a counseling session. Now, how are these records going to be delivered? Do we want to, or does the patient want them mailed, picked up, emailed, or again, sent to the portal? Here's the information for your medical records department there. And the government in their access guidance says that we can require a patient to sign our form. So if they're in the office, that works out extremely well. But if the patient states that they're coming in to sign this form would cause a burden or delay, then you must verify them over the phone. You do also have the option of sending this to them electronically and getting their signature in that form and format. Now, because again, we have a 30-day requirement, we definitely want to make sure that we keep for our own records the date that the records were sent. And again, we want to make sure that it's within 30 days of the date requested. This is a valid HIPAA authorization form. And what we mean by valid is that this form has all of the 9 elements required to make it legal. Without any of the 9 elements, even if it's signed by the patient, this is not a valid form and you cannot release medical records with it. So the most common use of an authorization is when an attorney wants to get a hold of patient medical records. And so we want to make sure that you use a proper form, or if you are presented with a form, that you make sure that it has all of these 9 elements on there. So first of all, we want to get the name of the patient, and again, to verify we've got the correct patient, we definitely want to get that date of birth as well. It is required to have on there who the records are going to. So we have to put in that information, and then also who's releasing the records. That's going to be our office, and so we need to put our information in there. A HIPAA authorization must list the reason for this disclosure. So is it a continued medical care? Is it for a legal follow-up? Circle or check the appropriate box. Now, what records are being sent? And again, we need to be specific here. So we should never have a patient sign an authorization form before all of this information is completed. So is this going to be all of the medical records, or is it going to be just office notes, diagnostic reports? And again, what is the range of the records that are being sought? Under HIPAA, when we are releasing sensitive protected health information, information that could cause financial, reputational, or emotional damage to that patient, the patient must sign or do a second step to release any SPHI. So even if this request said all of the entire medical record should be sent, if there was an HIV test, then whether it's positive or negative, that is sensitive in nature, and the patient would either have to circle this or come and check yes, some way take a second step. Many subpoenas will come with an authorization that says all sensitive protected health information is to be released, but it only has the patient's signature at the bottom. That is not sufficient to release SPHI. Again, authorizations have to have specific statements, such as the patient has a right to revoke it. It has to have a date of expiration. Without a date of expiration, again, this form is not good. For an attorney, it could be when the case concludes. So that would be a valid authorization there. This must also have the patient's signature or the signature of the personal representative. In our kit that you're receiving with this, you also have who qualifies and what identification is needed to determine that a person is a patient's personal representative. So make sure this form is filled out in its entirety. And again, it should not be filled out or partially filled out and have the patient sign it. It must be filled out completely before the patient signs this form. If you are in a practice that has substance abuse records, then we have to have a separate authorization to disclose any SUD patient information. The requirements here are very strict. We have a separate video on releasing medical records for substance abuse cases, and it's highly recommended that you watch that video and use this form as it meets the criteria needed to release these medical records. It does require, even from provider to provider, an authorization form signed by the patient, and these authorization forms must be very specific. Now again, a lot of proposed rules out there, and we expect very soon that the SUD rules will conform with HIPAA in a short period of time, probably by the end of the year. Again, we'll keep you up to date. So one of the items in your kit is a access guidance where we go over the 5 most common ways to release records and give you a little cheat sheet. So what right they have to access their records. Again, that designated record set. Can you require a written request? Yes, but not if it creates a burden or delay. There we have to go to our method of verification. These should all be documented. They are in our privacy policy for medical records released that we've included as a part of the kit. The form and format, basically, how does the patient want to get the records? Always best to recommend, because there's no charge that can be applied, for them to go to the patient portal. But if they want it in another form, do not argue with them. A patient complaint could easily cost your practice a lot of money. Timeliness, again, we've got conflicting standards, information blocking, access guidance. The best advice I can give you is make sure you produce medical records as quickly as your practice can in an affordable and economic manner. And the fees for copies, again, when it goes to the patient or at the patient's request, we must follow these access rules. When the patient sends medical records to a third party, then again, we have to follow the same rules as when the patient requests the records to themselves. Again, as to the right of access, all the way down to the fees that we can charge. So for provider continuity of care request, we are going to default to information blocking. HIPAA, as a standard, says that for continuity of care, we are permitted to share records, but nowhere does it say we're required to. That was one of the main reasons that information blocking rules came about. Now, under information blocking, we are required to share medical records for continuity of care purposes and do it as quickly as possible. So this is a new requirement under information blocking that says we must provide the records immediately or within a reasonable time frame. And if you do not know that the patient is a patient of that provider, then you must go through the information blocking rules and regulations and complete an exceptions form. Anytime you do not send medical records out under information blocking, you must fill out an exception form. Here, it would be the privacy exception. I don't know that they are a provider for this patient, so I'm going to ask for an authorization form to be completed. If you ask for an authorization form without completing the privacy exceptions, you are an information blocker and could be heavily fined. So make sure you do that. Now, under the fees for copies, it is permissible for a provider to charge a fee to send those records to you. The fee is not for you to pay, it's actually a patient fee. We don't see this happening too much, but it is out there. We do expect, again, the government is going to close that little loophole, and providers will not be able to charge other providers. As mentioned earlier, authorization forms are when a third party is going to receive the records. And authorization forms are very specific under the law. They have 9 required elements. If any of those elements is missing, you cannot release the records. It must be a fully valid signed authorization. So we have a nice little cheat sheet in the kit with you, and also include a valid authorization checklist. This is great to use with attorneys, because if you call them back and tell them, I'm sorry, I can't release the records because there's no expiration date, they're much likely to say, we're the attorneys, we know what we're doing, send over the records. This valid authorization checklist comes directly from the Office for Civil Rights. You can send that to them and say, without what the OCR requires, I cannot send you the records. When it comes to subpoena requests, there are 2 flavors. The first is when the attorney for the patient sends you the request. Again, it's going to come with a subpoena and an authorization. And again, that authorization must have all 9 required elements on there to be valid. Again, why 2 forms? Because an authorization only permits you to send the records. The subpoena demands that you send the records. When it comes to the opposing attorney, the government realizes that patients are not going to go sign the opposing attorney's authorization form. So instead, they allow you to do a notice of production or HIPAA release. Actually, that's going to be done by the attorney. If they've sent you the request, the subpoena, then it's already gone to the court. They've already waited the 15 days as required. So you can, without notifying the patient, release those medical records to that attorney's office. It is always my recommendation to take the time, call when it's the opposing attorney, let the patient know that you're going to be releasing their records per that request, just to cover yourself. And again, document that somewhere in the chart. Not required, but a good practice to get into. Included in our kit is a way to share patient information using a confidentiality list. Now, a confidentiality list basically goes over who we can release medical records to and talk to on the phone, contact in an emergency. The next slide has a full review of how to fill out this form. This is a confidentiality list used by most practices to allow a patient to disclose who we can share their medical records with. In the past, there's never really been a basis in the legislation for a confidentiality list. But now with the patient access guidance, we can turn this into a patient access request. Now, the first thing to understand is that we want to change out our current one with this new form, since it's based under the access request provisions. So we want to first put in the patient's name, and again, always use their date of birth as a way of making sure we're working with the correct patient. And here we have the medical records request. We've got it separated into 3 different options. The first option is the people on this list can be disclosed all of my medical information. They can even come in and request medical information on my behalf. So we've got only 2 slots here, but all you have to do, this is a Word document like most of our documents, is come in here and insert a cell below and add as many additional persons as you need. The second option is a limited option. And here, these are the people that can receive medical information in the case of an emergency, but do not have a right to get access to the patient's portal or to come in and request their medical records. So this is an emergency list. The third option is when the patient really doesn't want to share their records with anyone else. And under option 3, it gives them that right, but it also lets them know that if there is a serious or imminent threat of danger, and talking with a family member, friend, or caregiver could help alleviate that threat, we're going to discuss your medical information with them. So one of the really important things about this confidentiality list is that it also states on here that this is just limited disclosures. These are not all the disclosures we can make. We also have the disclosures that we can make listed in our Notice of Privacy Practices. That's an important distinction that must be on your confidentiality list, because if not, the patient could feel they're signing this and these are the only people that can get my medical information, which means you now would have to get an authorization to send it to another provider. You'd have to get an authorization to send it out for billing. So we highly recommend that you change this out. An access request does not have to have an expiration date, so this is good until the patient changes it. We have a lot of offices that I know give this to the patient once per year to allow them to update it, but that is not required. You may or may not have been updated on information blocking, but I assure you in the near future, you will be. It should have been named information sharing because that's really what this law is about. And because medical practices in the past, hospitals and other facilities have been a little slow, if never sending patient records to other providers for continuity of care, the government has stepped in with this information blocking regulation and stated that you must now share records. There are going to be serious consequences, and this is a pretty broad definition. Anything that is likely to interfere with the access, exchange, or use of EPHI, electronic health information, is something that if you do not send records, there are forms to fill out. They're in your kit under the exceptions forms. There's an excellent document, including in the reference guide, on using those exceptions. So if for any reason you do not send records, make sure that one of those exception forms is completed. The most common would be the privacy exception form. Another provider is requesting records, and just because information blocking says we're required to send them doesn't mean we still don't have to apply HIPAA. I've got to protect the privacy of that patient. I'm going to ask for an authorization form since nowhere in the record is it indicated that they are a continuity of care provider. But if I ask for that authorization form, I am required by information blocking to fill out that privacy request. If I just ask for an authorization, I could be found guilty of information blocking. Again, it's a very broad standard, and the privacy exception form is on the right side of your screen here. Again, any interference, patients seeking access to their own EHI, their own medical records, you could get in trouble just for discouraging a patient from getting or seeing their own medical records. So be careful there. Providers are, again, requesting medical records for treatment or healthcare operations. So be very careful. The rule now is to release medical records unless you've got one of those 6 exceptions, not to release them. Again, we've got another quick reference guide for you on the different exceptions. As a healthcare provider, there's a total of 8, but only 6 that you could use: preventing harm, privacy exception, security exception, content and manner exception, health IT performance exception, and the infeasibility exception. Again, on your video or on your kit is a video going over using these. We also have some great documentation from the government. I highly recommend that you spend a little bit more time and learn about these exceptions because, again, these are the only ways we cannot send medical records. They are expected to be rare and must be documented on a case-by-case basis. So we cannot use a general policy. Each case where we do not send records must be documented. I want to remind you that for continuity of care, there's a difference between HIPAA, a permitted disclosure, and information blocking, a required disclosure. I do believe we're going to see a lot freer release of medical records because Medicare fraud and high fines will be a part of the information blocking rule. So we've organized all of this information on this Releasing Medical Records kit, and we're hoping that this gives you all the information and documentation you need to properly release medical records, not have a patient complaint come in that could cost your practice time and resources. So this Releasing Medical Records Kit is a smaller portion of our entire HIPAA Compliance Kit and the regulatory binder. You need all of these parts to be fully HIPAA compliant. The risk analysis, risk management, a full set of privacy and security policies and procedures, HIPAA training for all of the staff, compliance officer certification, and also knowing and having all the forms and documentation for information blocking. So give us a call if you need additional service. We are here and happy to help. Thank you for your time today.